My name is Michael Pick, as stated, he, him, his, so thank you for that. So yeah, it's really interesting that a pop star, Britney Spears, would create a conversation regarding conservatorships, which is a really kind of niche, esoteric area of law. There's not a lot of attorneys in SLO County that practice it. However, the good result of it is that the California legislature is now looking at ways to improve upon the process, because some of the statutes that govern conservatorships are a little archaic. So with that said, conservatorships are not going away. 1 in 3 seniors in this country dies with Alzheimer's or dementia. By 2030, 1 in 5 Americans will be over 65. So if you look at the demographics of where we're going, conservatorships are going to blow up. They really are. So with that backdrop in mind, I'm just going to very quickly and simply cover what a conservatorship is. So a conservatorship is a court process where a judge appoints a person or an organization to care for another, to make decisions on those person's behalf. So some of the key terms: a conservator is the person that actually makes the decisions, that is appointed by the court. The conservatee is the person that's rights are taken away. It's very similar to a guardianship, however, conceptually. A guardianship is for minors, where a conservatorship is for an adult. Some of the typical situations that you see conservatorships is like what I talked about, when an elderly person has dementia and they start to decline. So often I'm involved in cases where there's a fight over who's going to control grandma. Sometimes those are veiled estate challenges. For one example, I'm involved in a case where an elderly gentleman won the lotto twice. So multimillionaire. And all of a sudden, all these family members from around the country are like, wait, I got to take care of them. So unfortunately, it's very contentious. Another example is it can be an outgrowth of a divorce proceeding. So you have a minor that becomes an adult that has challenges and needs to be conserved because a parent has to make decisions for him. So if a fighting couple can't agree on that, oftentimes it's an outgrowth of the parents fighting of who's going to make decisions. So with that kind of different scenarios in mind, I want to talk you through the process just briefly. So there's basically 2 laws that govern conservatorships. There's the probate conservatorships and LPS conservatorships. I'm going to talk about probate conservatorships because LPS conservatorships are based on severely developmentally disabled people, and they're instituted by a public agency. So the majority of conservatorships you see, similar to Brittany, is probate conservatorships, and they call it that because it's governed by the probate code. Underneath the probate conservatorships, there's 2 types. There's conservatorship of the person, where a person is appointed to make decisions on that person's personal behalf, where they live, what clothes they wear, what food they eat, what medical care they have. The other is a conservatorship of the estate, where a person cannot make financial decisions on their behalf, so an individual comes in and takes care of their money. So it could be both, or it could be one. It depends on the situation. So the process for a person to be conserved, it's a court process. There's a petition filed, a citation issued, and there's a number of different documents that are filed in the process that have to be filed. It's very specific, very technical, as it should be. Because in the process, you're basically taking someone's personal liberties and rights away. So there's a number of stopgaps that the court and the legislature has set up to protect that. First, all the documents that have to be filed. Further, under the California Probate Code, everyone is presumed to have capacity and competency until proven otherwise. So you have to have medical evidence that a person, 1, can not handle their affairs, or 2, are susceptible to undue influence. A court has to make that determination for a person to be conserved. The second is the court has to determine that this is the least restrictive means. Because you're taking someone's rights away, which could include social contacts, voting rights, everything, the court has to determine that there isn't something else in place that would care for the person, such as an estate plan, a durable power of attorney, or advanced health care directive, or some kind of spousal agreement that would allow for that. Along with those stopgaps is also the appointment of a court investigator who goes out, interviews the parties, and then reports to the court an opinion as to should the person be conserved, who should be the best conservator. We have 2 in this county. They do a fantastic job. The other stopgap is that the court appoints an attorney to represent the proposed conservatee. There's 5 of us in this county on the panel, and it's randomly selected. The court appoints us to represent the interests of the proposed conservatee. So not only do we do the investigative part of what's going on, but we also have to advocate for our clients, whether it's appropriate, what they want. And this is part of the legislation because of the Free Britney movement that's going on. There's going to be some clarification what those duties mean. In a conservatorship petition, a conservatee has a right to demand a jury trial, which is very unusual in the probate code because usually things are decided by a judge. So that's one protection in it. So in a nutshell, conservatorship is a very technical, esoteric process. Parting advice would be if you have a loved one that you care for, consider consulting an estate planning attorney because maybe you could avoid the litigation of a lawsuit over conservatorship to make those decisions in lieu of the court doing it. So thank you for the time.